person should go?
My Lord, the idea behind the rules is that
Forget the idea. Answer this question.
in fact, if we create a legal jurisdiction,
This is not, Mr. Secretary, please try to understand the court's concern. This is
my Lord, there will be legal complications if you allow. let's say,
Legal
an appeal.
complication state government has created. Yes, what is your name?
My Lord, I am Vinay Kumar, Secretary, Food and Consumer Protection.
You must have understood the difficulty which the court is facing.
Yes, my Lord.
So what proposal do you have?
My Lord, the view of the government has been there is a continuing process till the grant of the license. Selection committee is merely a recommending body, and the mere selection in favor of one candidate or the other does not create a legal right. This is what.
No, the only question is where a person should go if he is aggrieved by the selection itself. After grant of license, the matter is different. Do you leave it to the discretion of the licensing authority to decide the matter of grant of license despite the merit list prepared by the selection committee? No. The SDO will grant license on the basis of the merit list prepared by the selection committee.
Yes,
He is bound by that.
Yes.
So therefore, if in between that, if someone is aggrieved by the decision of the selection committee itself, which is headed by an officer of the rank of district magistrate, where the person should go?
My Lord, the idea behind the rules is that
Forget the idea. Answer this question.
in fact, if we create a legal jurisdiction of appeal immediately after the recommendation of this body, it will be duplication of the process of appeal which is after the grant of the license. That is one. That's the difficulty with us. Because this will be providing for two appeals in the
There
same
is no
continuing
question of
process.
two appeals. One is only relating to the selection. The other is grant and subsequent cancellation or
But my
whatever.
lord, anyone can challenge even the selection committee's recommendation
All
after
right.
the grant of the license.
All right, well, we can do one thing. No one can be left remediless. And therefore, there is a provision under the control order where all such persons who are aggrieved by the process of selection will go to the secretary.
My lord, in fact,
This is what we will be holding. Because yes, there is provision that any matter can be taken to the
my lord,
secretary.
if you permit me, I can make a submission in this regard. My lord.
so after grant of license, he will challenge it before which authority?
Before the collector, my lord, he is the appellate authority.
Under which provision?
Under Rule 32, there is a provision of appeal, and under Rule 32(3).
3.
Yes.
Please read 3.
All the cases against fair price shops licenses pending at the commencement. Just a minute. Just 32(3).
You must have read our order.
Yeah, I have read, my lord. Any aggrieved person, by an order of the licensing authority denying the issue of or renewal of the license to the fair price shop owner or cancellation of the license, may appeal to the district officer within 30 days of the order of the receipt of the order, and the district magistrate shall, as far as practicable, dispose the appeal within a period of 60 days.
So this is not, Mr. Secretary, please try to understand the court's concern. This is only if in pursuant to the decision of the selection committee a license is not granted, then only he can go to the collector. But if somebody is aggrieved by the selection itself, where does he go?
Because then, my lord, he will not be getting the license, and then this appeal option is available to him.
One. Very difficult.
That
My lord,
doesn't seem to be the
if you permit
purpose.
me,
All right.
I can
All right, that
submit
is-
something, my
that
lord.
is, Mr. Secretary, that is your interpretation of the provision, being head of the department of the concerned department. We will be interpreting the provisions, and prima facie we are of the view that as according to you they don't have any remedy, we cannot hold. We make it clear that we cannot hold that district magistrate in such circumstances, such circumstance shall be appellate authority. Also because he heads the selection committee itself. Therefore, in no circumstance he can be appellate authority. The commissioner is not appellate authority under the scheme of the order. You are the person who has the authority. We will hold that every person who is aggrieved by the process of selection will file appeal before you till you make a specific provision.
My lord, can I make a submission, my lord?
Mr. You must understand, there are three types of orders which are being passed by the High Court. One, where the court is directing the persons to go to the collector as you are suggesting. There is one order by another division bench which has sent the matter to the commissioner for taking a decision. There is a third order whereby the matter has been referred to the secretary for taking a decision against the process of selection. What is this? Let there be some consistency, and one must know where one has to go. So someone comes to the High Court to know where he is required to go, and that too under the direction of the High Court, not because of any provision.
Can we make a submission, my lord? Can we come out with an executive instruction for the detailed publication of merit list after the selection committee has finalized all the claims and objections?
We don't know. We are.
That
See,
would bring everything transparently.
Mr. Secretary, if a person has no remedy, he has remedy under writ jurisdiction, he can come straightway to this court to enforce his right. If you have decided that you will not have any forum, we will deal with the situation.
And reliance
Mr.
placed on 32(3) is, you have to have a relook at 3. It is a person agreed by an order of the licensing authority, and licensing authority is defined under 4. He is the subdivisional officer, and denying the issue of or renewal, not grant. So he has, if he is aggrieved by non-issuance after the decision of the selection committee, then only he can approach under this provision.
Or you can clarify in the order.
Or you can clarify that yes, all orders will be challenged, and the provision as it appears to be a provision only granting a redress against to a person who, in spite of the decision of the selection committee, his license is neither being issued nor renewed. Then he may approach the collector. We are being faced with every day with a circumstance where they are aggrieved by decision of by the committee under section 5, under clause 5. Where do they go? Because there the collector is sitting in the selection committee. How can he again hear an appeal from the decision arising out?
So we have before us at least 20-25 cases for deciding the manner in which this selection has been met. You say that the collector will decide. We are satisfied that the collector has no jurisdiction.
Cannot be.
Then either this court or you.
Or under 7, it will be all of it will have to go before you. There appears to be no other remedy, and there will be hundreds of selection in every district. It is your call. That is why just we wanted to know your view.
And
Whether you want to provide an appellate.
Your view is view of the state government of Bihar. It's not an ordinary view.
Yes, my lord, I understand.
And rather we are shocked. How have you placed reliance on Rule 32(3)?
We cannot be.
Surprising for us. In one of the decisions we have recorded, in one of the orders we have recorded that cannot be a provision for appeal in such circumstance.
My lord, there will be legal complications if you allow.
Legal complication the state government has created. Legal complication is this is why every person who is participating in the process of selection is compelled to come to this court if he has to challenge the process of selection.
My lord, if we clarify that even
The High Court is not understanding, Mr. Secretary. The High Court is not aware as to which is the forum, and therefore in one case collector, in the other commissioner, and the other in yet another case secretary, and no one knows who is the competent authority.
We are not suggesting you create any kind of complication. We want you to iron things out, specify, clarify who is the appellate authority. When a person who participates in the process of selection and he is not selected, how can he resort to 3? 3 is totally different. It will be for that person who has been selected and he is not being issued license by the licensing authority. Then only he can go to the collector, that it is not being issued.
our apprehension is one simple apprehension, my lord. That apprehension is if we allow an appellate jurisdiction immediately after the recommendation, then the whole process
we are
will
saying
get
even
stopped.
after selection, after grant of license, where will the person go who has participated in the process of selection and he is not a selected candidate? Under which provision?
We believe it is rule 32(3), my lord, but we can clarify it and we can
No, if
include
that
the
is your
cases of-
stand, then we will have to deal with it. We were
We
expecting
may indicate.
a resolution.
We may indicate at this stage that if you notify collector as the appellate authority, that notification may be unconstitutional.
Yes.
That notification may be unconstitutional for the reason that he cannot sit over appeal over his own
Own
judgment, that too decision of the committee presided over by him. Therefore, neither the provision can be read like that, nor you should make a provision. We are not here to advise the government how to frame law and make rules, but at least we must clarify to you because so many cases, everyday cases are coming. This is one division bench, the other division bench, there are so many cases. In third division bench, there are many cases pending. And even in some of the cases, you have taken this, there are affidavits filed by the department that collector has no appellate jurisdiction. How can you take this stand? We have seen affidavits filed by
Yes, my lord.
the department.
In
that-
this batch of cases only.
Yes, in this batch of
Yes,
cases,
yes, yes.
that the collector has no
Yes.
appellate jurisdiction, you are taking a plea that the collector
Precisely
has
because there
appellate
is no such
jurisdiction.
provision in the rules at this juncture. So,
And-
Or you can
What I'll-
take a plea, you can say that no appeal, no, there shall be no remedy, or no, that shall be final, and that cannot be questioned in any court of law. Such provisions are made by you.
my lord, I'll pray that this case be adjourned and we'll examine the matter threadbare now. So
You-
I think because we'll have to think through the whole things. Because we are thinking of creating one more appellate channel before the grant of the
There
license.
is no question. Mister, you don't create a channel, but at least someone who has grievance against the process of selection, he has a right of redressal of his grievance before at least one authority.
My lord, will it satisfy this honorable court if we make a provision by way of figurative instruction that the divisional commissioner will look after the grievances?
That appears to be the only possible solution.
And that
This
is the
can
most
be-
workable solution.
Yes.
That can be, that will be done even without
All
making
right.
any amendment in the
Yes,
TPDS
All right,
conclusion.
Yes.
and do that.
Okay, my lord.
We will
We'll
take up
comply
the
with that
matter
instruction, my lord.
on Wednesday. We will take up the matter on Wednesday. In the
Some more
meanwhile,
sufficient time, my lord.
all right, Thursday, because there are so many matters pending.
My lord, give me around 10 days time because it will have to be cleared. Give me 10 days time.
We are giving you, but it will come on Thursday then, next Thursday. Not this Thursday, next Thursday, on 19th.
We'll comply with the instruction. The only request is I may be exempted from the personal business.
Yes, yes. Your personal appearance was for a different purpose. It was because of your presence that the matter is going to be resolved to a great extent. Had you not been here, the matter only because at times we raise our voice. You should not take
Even
that
last
otherwise.
time, my lord, after the court's direction, we amended the TPS control.
We make observations in public interest. We do not have anything against anyone, and we wanted your presence. We had made it clear that it is not because of any anguish which the court is going to express against the state government, but because of finding a solution to resolve such issues.
We'll come
So
out with
your
the solution.
presence is going to contribute a lot in this, because for the first time this aspect is being addressed and on this level. Therefore, if you are in a position to, or if you, that will serve a great purpose. Otherwise, just think of. We always suggest that please empathize. Place yourself in the shoes of the persons who are participating in the process of selection. They have a hope of getting selected. Once they are not selected, they find some forum to go before. They don't know. Even the High Court does not. Therefore,
We'll comply with the instruction.
Let there be clarity, let there be consistency. It is not you will not be, you are not required to provide that once the selection is selection process is finalized and till decision is taken by the commissioner, the licenses cannot be issued. It's just at any stage, please let there be some forum for the persons who have a grievance to approach.
We'll comply with it.
That is the only concern, not otherwise. And your presence we don't need. Your presence we may need for two reasons. One, if we require your assistance for resolution of such things. Two, if you disobey some order. There are only two circumstances.
And plus, prior to your appearance in these proceedings, your department has been taking shifting stands regards the appropriate appellate authority. The court has suggested 3 forums. You have not challenged those orders to ascertain or finally determine which will be the appropriate appellate authority. Just see.
We'll come out with a
Please do. Please do. We will exempt your personal appearance.
Thank you.
In view of the observations made by this court when these matters were taken up in the first half, the Principal Secretary,
I'm Secretary, ma'am.
Secretary, Food and Civil Supplies Department, Government of Bihar, is present. First off, he has assured this court that the department shall consider in all seriousness the issue of having a definite forum for such aspirants for grant of license under BTPDS control order who are not selected and claim better merit than those selected. First of all, he has sought adjournment till 19th. And has stated that in the meanwhile the state government shall make endeavor to come out with a definite decision.
Yes, ma'am.
So stop. Next, as requested, list this matter on 19th as to be taken up at 10:30. From next, personal attendance of the secretary shall remain dispensed with till further orders. So don't, even if we direct your personal appearance, don't get worried about that. That is for
The last time also we amended the TPTS.
right,
Yes.
and therefore see what is the effect of that amendment. So this is how the things improve.
Like that.